Therefore, my lord, the distinguishing feature is, my lords, where prior approval is sought by a police officer and which has been granted as against a private person seeking a prior approval, my lord. So just your lordship may kindly see section 17A for a moment, my lord. It says that no police officer shall conduct any inquiry or investigation to any offence alleged to have been committed by a public servant under this act. Then, my lords, where the alleged offence is relatable to any recommendation made or decision made by him, taken by him, by such public servant in discharge of his official functions or duties with the previous approval. Then, my lord, second proviso is important, my lord. Provided further that the concerned authority shall convey its decision under this section within a period of 3 months. So therefore, my lord, the condition precedent for this is, my lord, there should be a preliminary inquiry done by an investigating officer, my lords, which has to be placed before, given along 17A, my lords. The reason is this. When
to get clarification, sorry. Now, are you suggesting that prior to 17A approval being granted, there should be a preliminary inquiry?
As held by Lalit Kumari, that is what the your lordship is.
Then you are equating 17A order to an FIR.
No, that is why your lordship is.
If you're equating 17A order to an FIR, preliminary inquiry is necessary. Otherwise, yes.
Therefore, my lord, if your lordship sees my lord, Lalit Kumari clearly says, my lord, in so far as cases of corruption cases.
True, para 120.1.
1 and
6 postulates there.
6 postulates. We come in clause D, C, and E, my lord.
Yes.
If we come under clause C and E of Lalit Kumari, my lords, it is mandatory that a preliminary inquiry is done. I'm not talking about inquiry as contemplated under 17A. What I'm saying is pre-17A. Your lordship may kindly see pre-17A is a mandatory requirement.
Pre-17A, all the 3 circumstances, inquiry, or investigation.
I'll be able
for all the 3, you need 17A approval.
Correct.
Where is the question of the 17A, prior inquiry under 17A without compliance with 17A?
So, your lordship may, I'll take Lalit Kumar, your lordship may kindly see.
Please take para 120.6,
Please,
2014-21, page 1. Yes.
This court written submission, I've just culled out the relevant paragraph. Photos.
ಅದು ಓದಿ ಹೇಳಿ ತೊಂದರೆ ಇಲ್ಲ 14-2 SCC page 1 para 120
Your lordship may kindly turn to page 61, my lord, of my at page 62 or 61 it starts.
There is a list of other written.
No, just a notes, instead of going to all the judgments, my lord, whichever judgment I'm relying upon, I've culled out the relevant paragraphs, my lord.
All right.
As the lordship pointed out, my lord, that 120.6 D and E, my lord. 120.6 as to what type and which cases preliminary inquiry is to be conducted will depend upon the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under.
So,
D and D, where the case is abnormal delay in latches. This is a case of 22 years, more than 20 years, my lords. 1998, according to them, my lords, is a case of denotification, assuming for. No, I'm saying it is a case
you're
where.
Thinking to that. Yes.
Please.
Where there is abnormal delay.
Abnormal delay. So
then you may be just.
Please. So.
All right. Yes.
So therefore, my lords, coming under D corruption case and under abnormal delay, my lords. So question is preliminary inquiry is mandatory. So therefore, my lords, that is why, my lord, the language used first portion, no police official shall conduct any inquiry or investigation, so and so, as committed by a public. If your lordship read the SOP, my lord, which will give further more clarity. Your lordship may kindly take volume 1.
Page 703.
Please, my lord.
706, yes.
That's the crux of the whole thing, my lord.
Volume 2, 706.
Absolutely, my lord.
Yes.
Annexure M, my lord.
Yes, sir. SOP of the Government of India on 17A.
Please, my lord.
Yes, sir.
So the private person cannot be put in a higher pedestal than a police officer, my lord. What, assuming, my lord, the preliminary inquiry has to be done. This is what the crux of the whole 704, my lords.
Hmm.
So as to standardize and operationalize procedure with a view of achieving uniform and effective implementation for prior approval processing under 17A of the Act, the set of SOPs are hereby conveyed. First stage processing of information received by the police officer. In this case, my lords, this has not been done. Then, my lords, 705, what as your lordships were pointing out, standard operating procedure for handling information in respect of a public servant alleging offense under the PC Act, seeking of previous approval for conduct of inquiry or investigation under Section 17A. Then, my lords, clause 2, it may be emphasized that the provisions of Section 17A stipulates a mandatory requirement for a police officer to seek previous approval for conducting so and so, so and so, so and so, alleged to have been conducted. The police officer upon, this is the requirement, 3.2.
No, that would bear reference only to a crime registered before a police officer. No, that would not cover private complaints. Private complaints was a
Yeah.
concept that was evolved by this court in GV Ashok, so that SOP won't help.
No, it will help. The reason is it is a case of private complaint before the police officer.
Where?
Here is a, not sorry,
complaint
private, a
before-
complaint registered before a police officer. That I'll come to 154, 173, 1 and 4 much later, my lord.
Hmm.
Here is a case where a complaint is given to a police officer, sufficient time is not given. They jump the gun and apply for 17A in compliance of your lordship judgment in Dr. Ashok's case.
Where is jumping of the gun here?
Because, my lord, I'll come to the facts with regard to 150. Why preliminary inquiry, what is stipulated, that is 15 days to 6 weeks. They don't wait for that. Then they apply for 17A for compliance of Dr. Ashok's case. So therefore, my lords, what has to be read is the preliminary inquiry. Ultimately, my lords, the governor does not do the preliminary inquiry. He only grants prior approval. In this case, what has happened, my lords? He sits as a preliminary, does the preliminary inquiry. That is hearing the complainant for 1.5 hours, according to them.
All right.
Then issuing show cause notice, seeking clarifications, seeking reply. So therefore, my lord, that is the sole jurisdiction of the police officer as per the SOP and as well as the judgment of this.
And even as per 17.
As per,
17A.
I'm born into it. I'll just point out, highlight a few aspects in this SOP. Your lordships have read, my lord, just to.
Sir, you can.
Then clause 4, my lord, page 705, 3.1, Roman 4, Roman 3, specific acts of commission or omission attributable to such public servant, whether such acts are relatable to the official functions or duty by the such public servant, specific to the office post held at the time of commission of the alleged offense, specific recommendation or decision taken by the, my lord, all these aspects are very crucial because this says when the police officer or the investigating officer seeks for sanction, these requirements has to be placed before the competent authority. Then, my lord, page 706, that Roman 4, the proposal of the police officer of the appropriate shall contain the following information. So therefore, my lord, the proposal is the formation of an opinion by him prima facie that cognizance of this case has to be taken. 4.4, the appropriate officer of the appropriate rank shall make a proposal of the to the appropriate government, as such case may be through a single window process as laid down by these SOPs, and shall ensure that the proposal is in accordance with the requirement laid down in the checklist, enclosures, clear, legible and authenticated documents as may be required. Separate proposal shall be submitted for, this is important, what your lordship just said. Separate proposal shall be submitted for inquiry or investigation as the case may be. Your lordship may now kindly see the page 707, my lords. What it says, the incomplete proposal should be sent back by the competent authority back to the investigating officer. Then so therefore, what is the approval which speaks previous approval is the proposal sent by the investigating officer. In this case, my lords, or if I'm giving a hypothetical, tomorrow all citizens or any busybody goes, gives complaints against everybody, my lords. All the,
That's precisely why I wrote prior approval is needed.
Dr. Ashok has said, because it first compliance of 154, prior approval, then comes the complaint. Here, my lords, what has happened, as I said, 154, here, my lord, even what is applicable to a police officer, the same procedure ought to have been applied, the competent authority to,
Followed by the governor?
no, governor ought to have asked the private party to say that, give the information with regard, there are two aspects, my lord.
So much of information is given.
No, with regard to the format, allegations have been given. My lord, there are two aspects, my lord. One is formulation of an opinion can be done only by the investigating officer, not by a private party. His opinion will not make any difference. So therefore, there are two stages. One is you ought to have given as per the requirement of law. Once having received it, my lords, the competent authority does not act, does not do the preliminary inquiry. It is the competent authority could have asked, as required under law, the investigating officer to give the information. He ought not to have sat as an inquiry officer, investigating officer. In fact, Your Lordship, what is page, if Your Lordship see page 709, the checklist goes to show, my lords, when prior approval is given, the competent authority has the benefit of all the material and data which is required under 17A. Can I read the page 79, the checklist, my lords? First is name and designation of the office held by the public servant. Then post or office held by the public servant at the time of the alleged commission. Then whether the request is based on a complaint received, if yes, copy of the same. Whether the complaint prima facie reveals deriving of an undue advantage by a public servant, whether any information is available in respect of bribe given, then please provide specific details of recommendation made or decision taken by the public servant, which is relatable to the offense alleged against the public servant. In case of preliminary inquiry was undertaken at the early stage, please enclose, my lord. Then whether any criminal offense. So therefore, my lord, this is what is approved under 17A, which goes to show that there is an application, preliminary inquiry done, there is a proposal, there is a report, and application of mind is to this. Therefore, my lord, my submission is on point of law is, my lord, is that the allegation or the complaint which was sought for under 17A ought to have been returned. Second aspect is, my lords, if it was accepted, preliminary inquiry information, instead of asking the complainant or the show cause not having issued to the petitioner, it is information ought to have sought for from the investigating officer in terms of 17A or the SOP issued by the central government. That's my first submission. Therefore, my lords, I'm not going into as to the rest of the process. The main thing is you ought not to have entertained the application itself. As your lordship initially pointed out, my lords, 17A does not contemplate preliminary inquiry. I bow down to that. What is requirement of Lalit Kumari and your lordship's line of judgment, my lord, that preliminary inquiry is mandatory, is what ought to have been followed. Lordship may just the next aspect is, my lord, insofar as recommendation is concerned, next is the heart of the whole thing is, my lord, is whether there is any recommendation or decision made. My lord, it applies both ways. What ultimately the argument will say, I don't need the protection because I am not in any other case, if 17A application, if the protection, if we are seeking saying that it does not come within the 17A, the protection under 17A goes. Here,
if you do not offense under the PC Act illa andre.
PC Act, that is under.
All right.
So therefore, my lord, what is crucial, my lord, is that offense has to be relatable to decision, recommendation, and the office head. Head. The Lordship may kindly see 2-3 judgments on those lines, my lord. I just reproduced it in my compilation. I just would like to take a Lordship to the relevant paragraph, my lords. Lordship may kindly turn to page 27, my lords.
Yes.
This is Nara Chandra Babu Naidu versus State of AP, my lord, 2024 ACC online. I'll just read para 3 just above that, my lord. In this context, the current case, these definitions underscore the importance of establishing a clear connection between alleged corrupt act and the official recommendation or decision, linking the same with the public servant. This interpretation reinforces the protective intent of Section 17A, ensuring that the public servants are shielded from unwarranted investigation from acts not directly connected to their official duty. Para 55, in para 4, Section 17A has the following 4 more facets. Inquiry or investigation of the offense under PC Act. Alleged offense should be related to the recommendation made or decision taken by a public servant. Such recommendation made or decision taken by the public servant should be in discharge of his official functions or duties, and the previous approval of the authorities mentioned therein. My lord, in fact, in B.S. Yedurappa's case, my lord, case of denotification, the division bench of this court, my lord, in para 31, I've just quoted that as said, even otherwise, the order of denotification passed by the petitioner, in this case, it's not passed by the petitioner, para page 31, in the circumstances discussed above, cannot be construed as any recommendation made or decision taken by the petitioner in discharge of his official duty so as to attract Section 17A of the PC Act. So, my lord,
Yes.
this is, and next, my lord, even the Gujarat High Court also has held on identical. The word relatable is an adjective. The legislature in this wisdom has used adjective relatable to connect the offense to a recommendation made or decision made. Therefore, such approval shall be required when the offense is associated with and connected to a decision taken or recommendation made by a public servant in discharge of his official duty or function. Use of the adjective relatable to the offense is considered opinion of this court, limits and restricts the offense to be associated with and connected to a decision taken or a recommendation made by the public servant in discharge of the official duty or function, and therefore can't be extended to all offenses under the PC Act. The same is Madhya Pradesh High Court, para 6.3. Section 17A is attracted only when the offense alleged under Section PC Act relates to the act of recommendation made or decision made, but is not attracted when the offense relates to demand or acceptance of bribe, taking to an illegal gratification or disproportionate.
No, that's why trap cases gate is not applicable.
Please, my lord. Then last is Kerala High Court judgment, my lord. Ultimately, my lord, that is why the SOP becomes very, very important, my lord. The checklist gives for the purpose of formation opinion, para 9. The most crucial part of Section 17A provides that the previous approval is required in relation to an inquiry or investigation into an offense alleged to have been committed by a public servant under this Act, where the alleged offense is relatable to any recommendation made or decision taken by the public servant. It seems that the above part of the section is most crucial part of the section, since imposes a rider that otherwise the absolute power under Section 17A, so and so, so and so and so and so, in every act needed prior approval.
Yes.
My lord, next one other aspect, my lord, if your lordships kindly turn to page number 13, my lords. This is with regard to Yashwant Sinha versus CBI, with regard to preliminary inquiry, my lord, just going back.
3.
Page 13, my lords.
Yes. Sirajuddin is followed.
Sirajuddin is followed, Yashwant Sinha and Prabhat Kumar Dubey, my lords. the reason I'm using the preliminary inquiry, my lords, preliminary inquiry has to be, so even in case of Sri Rupa, my lords, what the courts have said that while doing the investigation officer should have credible evidence based on which an opinion is formed by him for the purpose of seeking of prior approval under 17A. So therefore, my lords, in this case, my lords, I mean,
According to you, the petitioner has not done anything that is relatable to a decision taken or a recommendation made.
I'll slightly modify it. What is not there in this is, my lords, it is only an investigating officer who can give,
No, I'm only asking a simple question.
please, my lord.
According to you, the petitioner has not done anything that is relatable to it. Sir, petition, you're appearing for the complainant?
No, your lordships are saying
No,
petitioner
no,
is
no.
accused.
Petitioner is accused.
Okay.
That is what I'm saying. According to you, you are for the government, right?
Please, please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that.
Hmm.
That's the legal position, my lord. In order to invoke 17A,
Hmm.
that is a condition precedent, my lords. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is even for an application seeking prior approval under 17A, there should be a preliminary inquiry as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry and the competent authority himself has now acted instead of referring it to the police for preliminary inquiry as an approving authority conducting inquiry himself and passing an order. That is your submission.
Second submission. And the third is, my lord, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the three requirements, my lord. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third, most important, in discharge of his official.
Correct. That is there. That is the
Therefore-
soul of the, see, that is the soul of 17A.
17.
In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordships have said, what is the object and purpose also of 17A
Yes,
is to
that-
protect the thing. And why it should not be abused also, your lordships have dealt in Dr. Ashok and Pradeep Kumar
All,
and all those cases.
all right.
Keeping those in mind, my lord, the question, what your lordships lordships will decide is, my lords, not only in this case, any other, I mean, on a principle of law, my lords, a trigger-happy complaints are filed day in, day out against various public servants to the competent authority, my lords. Then the nature of inquiry, again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, my lord, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, my lord. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only a police person, my lord.
Oh, you're coming at that.
I've been trying to come at that. my lord.
Yes. All right. Yes.
So therefore, my lords, ultimately, unless that report is there, that is what, I mean, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, there may be, ultimately, my lord, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
Report of the investigator.
investigating. He independently, he gives approval to, therefore, my lord,
Approval for what if there is already a report by the investigating officer?
no, therefore, he may accept it or reject it.
No, approval granting in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, my lord. So therefore, my lord, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offense which the investigating officer forms in view of the bar under 17A.
Hmm.
He has to seek permission from the competent authority, and the competent authority gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumar's principles.
Principle. Then, Manoj, your lordship, the lordship circular also may be kindly seen, Manoj. Volume one.
Lordship circular, High Court circular.
Your pursuant to your lordship's
Order,
pursuant to your
Ashok, yes.
lordship judgment in
Page-
Doctor.
Page, Dr. V. Ashok or something, yes.
Please, Manoj.
Page,
That is-
sir.
That is at page number, Manoj, volume 1.
Citation, madam. Volume 1. Put in.
Page 260.
2?
60. In fact, Manoj, what you're keeping in mind, the object of 17A, Manoj, what your lordship said, if
60.
260, volume 1.
1 second, sir. Of the
Petitioner's paper.
Petitioner's volume.
petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page numbers, but I need not.
No, ಯಾವ volume ಅಂತ ಹೇಳಿದ್ರೆ volume also I should know. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
That's why.
easy to remember.
ಅಂತ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Shivasa, Manoj.
And Yashwant Sinha
uh,
later.
Please, Manoj.
Yes.
That is affidavit 173-1 and 173-4. I'll come to that, Manoj. Here, page 261, Manoj. The language, what your lordships has said at page 261 is, Manoj, even if not to entertain such complaint if they do not comply with the following. That is, Manoj, one is registration of the complaint, then prior approval in case of a prior complaint. Then last paragraph, Manoj, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave as an exception, such complaint shall bear the scrutiny so and so. So therefore, my lord, pre-requirement is compliance of 154 or 173, then 17A. So therefore, my lord, again, my lord, here comes back to Lalit Kumari once again, my lord, because it has, there is no application of mind or not application of mind, no preliminary inquiry. I put it, the language used by the Supreme Court, my lord, no preliminary inquiry done in this matter, my lord. And coming back to insofar as 154 and 173, your lordship may kindly see on the 3 volumes were given by the counsel for the governor, the solicitor general, my lord. If your lordship sees, my lord, on those volumes, there is no complaint is given by respondent number 3. Respondent number 3 on 18th July and 25th July, my lords. And the immediately next day,
26th July.
26th July, immediately next day, prior approval is sought. So therefore, my lord,
Prior approval is sought and show cause notice is issued.
no,
on
the
26th.
points I'm trying to make here is, my lord, the question is,
No preliminary inquiry.
so therefore, he had not given an opportunity to conduct that inquiry. If he had given, we don't know whether the police officer themselves might have or might not have sought for prior up.
No, if your submission is accepted, that permission was not given up to
Sufficient time.
sufficient time or whatever. 17A ಆದ್ಮೇಲೆ ಅದೇ ಆಗೋದು.
No, that's a different aspect, my lord. No, just because it's going to happen after 17A.
Not just because, only because.
No, only because, my lord, your lordship, go by to the Supreme Court judgment and the judgments of your lordships and the SOP cannot given a go by because it is likely to, the scope of that is entirely different. Mala, once the complaint, 156.3, that's entirely scope. I'm not on.
No, if you're hinting on some inquiry, investigation should happen. Now, if the impugned order, I mean, like, by the impugned order, what is done is that only.
That he could not have done. That's the whole point, Mala. He is a competent authority, not a preliminary inquiring officer.
All right, yes,
That is what is prohibited in law.
all right.
Sum and substances. So therefore, in fact, para 3 and para 9 of the written submission says, we have done preliminary inquiry. We have not taken a given prior approval. Your Lordship may kindly see the written submission given by them,
By whom?
the Solicitor General, my lords.
Sorry?
All they say that we have done a preliminary inquiry as required in Lalit Kumari.
That is prior to giving approval.
By the competent authority.
Prior to giving approval.
By the authority.
So according to you, police officer should do that.
That's what the law says. Your Lordship, that is the requirement, my lords. So therefore, the application of.
Sir, two things.
Please.
If the crime is registered before the police, now if it, or the lokaयुक्त or whatever it is, if it is touching upon or an amalgam of offense under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
Correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. All right. Now it is a private complaint. Straight away, a private complainant goes before the court. He seeks reference under 156.3, now under 175 of the BNSS. Now, if the matter is straight away referred, now say it is
not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to jurisdiction police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what?
By way of a private complaint, you obviate the process under section 17A and straight away get a crime registered where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the lokaयुkta, 17A would be required. All right.
Correct.
Now, 17A, the approval is sought before the competent authority. Here, the competent authority is the governor. Governor initiates certain process, do not that day it is granted or what day it is granted. How it has been granted?
I'm not on that.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now in the written submissions, the learned SG says that preliminary inquiry is conducted
by the
as contemplated under Lalit Kumari by the competent authority.
Which is not
that is your submission.
It's virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority. What is sought by the investigating officer? That's the summon. And what the whole case and the record shows that 25th was the complaint, 26th the file movement. He was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Malots? It is of the written submissions.
Yes, sir.
Page 9, para 3. It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offense and apprehension exists that offense may have taken place, requiring an investigation to be conducted in accordance with law. Para 9, can I request?
Yes.
That is at page number 12. It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so-and-so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognizable offence is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so on, so and so, and the understanding that the FIR is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, my lords, who has to do this preliminary inquiry? It's not in dispute according to them also, my lords, that preliminary inquiry need not be done. According to them also, it has to be done. It says, I will do the preliminary inquiry. So therefore, my lords, there is no doubt that preliminary inquiry has to be done, even according to them. Then, my lords, page 14. Para 10.
All right.
I'm sorry.
Yes, yes, no. For whatever is to be done, preliminary or otherwise, 70.
Please, my lords.
Yes.
My lords, what my submission is, preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17A.
All right, we'll consider. Yes.
Para 10, it is submitted that for the approval of investigation must be exercised by the, guided by law laid down by the Honorable Supreme Court. It submitted in the case of information given to the police, discloses the commission of a cognizable offence, the approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure the proper investigation is conducted in the present matter, to merely uncover the truth in the matter and to take not to take any specific sides.
So according to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. Ultimately, what they said, we have followed Lalit Kumari.
Hemant Naidu,
Then one of the important aspects, my lords, with regard to your lordships, I have held in Dr. Ashok's case also, my lords. In this case, my lords, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ordered to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard
After a few days.
No, not after, whether he could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there's no such procedure. Rightly, my lord, there's no such procedure to hear the private citizen or a complaint. My lord, especially, my lord, when at the cost, allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question, what your lordships will consider whether application of mind, principle of natural justice, reason order, I don't want to go into those aspects.
So you are at the root.
The root
It cuts at the root.
Because the third, fourth, and the fifth complaint, my lords, here also I am not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7.
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given from the governor's compilation, my lords. On 18th July is the complaint given to the inspector of police, my lords, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, what, I'll come to my opinion later.
No, that's what I said, because
No, they have
no,
to.
now you're saying that police officer has to register, police officer has to seek permission.
No, what, they're slightly different, what the opinion is given, what I'm submitting, my lord. Here, my lord, if they are complied with 154, my lords, as I submitted earlier, it is, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, he would have, if it's a cognizable offense, he would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be compliant. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lord. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154.1 is not followed, or 173.1 or 173.3.4 also is not sought to be.
151,
ನೀರಲ್ಲೇ ಬಿಡುದು
154, 1 and 3.
1 and 3 has not been.
171.
No, so I'm saying-
ಮಾಡ್ಲಿಲ್ಲ
but
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ನೀರಲ್ಲಿ ಬಿಡಕ್ಕೆ
Please, ma'am. So therefore, my lords, to entertain that application also, application 17A, my lord, this crucial aspect, whether the compliance of 154, my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. And in fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. And the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to have not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords,
163.
163.
Hmm.
Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords, on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given grant, the aid and advice is to grant sanction, and the same is rejected. It can work both ways. In this case, my lords, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other.
Not to grant sanction, but sanction is, but sanction is to grant sanction, sanction is not granted.
Not granted.
All right.
So therefore, my lord, this discretion is not his absolute power or absolute discretion which he can exercise. This is limited to what has been held by the Supreme Court in MP Police and Justice Punchi's judgment and Nawab Rabia and all these judgments. Ultimately, I just like to write 2 paragraphs of the judgments, my lords. My lordship may kindly take to page number, my lords.
48.
Please. Page 41 for a moment, my lords.
The discretion begins there. Your submission is at page 48.
Okay. Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just, where is that paragraph? Your lordship may kindly turn to page 55, my lords. At point number 4.
MP Police.
Which has been reiterated in AG
Yes.
para 4, my lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principles established in MP police establishment, Nawab Rabia, and so on and so on. So the exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Council of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision-making, raise serious question how the propriety and legality of the impugned order potentially infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Lordship, may turn to page 43, Malats, for a moment.
Yes, sir.
The 43 last paragraph, Malats, 4.2.15
Yes.
explains, referring to Shamsher Singh and M.M. Punchi's commission's report, Malats. It's just been culled out over there,
Yes.
which page 43 highlighted portion. Malats. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of two clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the Council of Ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of exercise of discretion covers all or any of the function to be exercised by the governor under the Constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by person, actuated by good faith and tempered by caution. So
Prudence, caution, all right.
So, Malot, this is the, so therefore, Malot, the Lordships will see, Malot, whether the impugned order comes within the four walls of this aspect. So therefore, Malot, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, Malot, it should be by reasons with which the reasons should be in the order itself, not in the file, Malot. I would just like to take your Lordship to the file for a moment, Malot.
Which file?
The governor's
Oh,
file.
right.
Just I'll end with that, Malot. Just want to point out 2-3 aspects
Yes.
in that, Malot.
Madam, copy ಕೊಟ್ಟಿದ್ದಾರೆ. Copy ಕೊಟ್ಟಿಲ್ಲ.
Volume
No, it's in volume.
1.
That's the order.
Oh,
Impugned
the order sheet.
All.
Proceeding.
Yes, yes.
If
Page.
page, Malot, page 1, Malot.
Ah,
If your Lordship sees, Malot, reference subject is sanction for prosecution, Malot, of so and so. Petition, so and so dated 26/7. Kindly produce petition by so and so, serial number 1.
hmm.
Then next page number 2, Malot.
Hmm.
Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, Malot.
Hmm.
I have heard so and so in person and gone through the petition and supporting documents submitted by him.
Hmm.
Prima facie, I am of the view there might be irregularities and misuse of power.
Hmm.
Hence, show cause notice to so and so within 7 days.
Hmm.
So this is what the preliminary inquiry sought to be done, Malot.
Hmm.
Then can I request, Malot, page 7? Speaks about, Malot, the reply given by the petitioner, then the proceedings. Then last at para 20, my lords, put up along with the comparative statements of petition, chief minister's reply and cabinet decision. Then at page 8, my lords, as directed at para 20, comparative statement of petitioners received so and so, so and so, so and so, reply are placed in the file for kind perusal. Perusal file discuss the issues, hence resubmit, kind notes, points dictated. Then this is page 9, para 25 is important, my lords. Insofar as TJ Abraham, my lords, what is taken note of is the 26th July. Insofar as Pradeep Kumar, my lords, is 14/8, and my lords, Siddaramaiah Krishna is 5/7, my lords. 5/7 pertains to referring the matter to CBI, not the additional memo which is thought to be filed on court. So therefore, my lords, what was sought to be argued on principle of law, my lords? In fact, your lordship's judgment in Ashok and Pradeep Kumar all says the reason should be in that order itself, my lords, because it is a 17A is a protection given to the public servant. The files or the notings in the
So file notings will not supplant
supplant
what is not there in the order,
what is
or
there.
supplement what is there in the order.
order.
Not
So
supplant.
therefore, to say, my lords, I did A, B, C, D, E, F, G, but my order may be wrong. But look at A, B, C, D, E, F, G. Ultimately, my lords, what is looked into is the order. If the order is bad, it's bad. So don't try to, as your lordship says, supplant the file to look into the order. If the order does not satisfy 17A, my lord, the order has to
Go.
go.
Yes.
So therefore, my lords, insofar as this legal, because these submissions are made on what the, therefore,
So, understand? Any other submission?
that's it.
Your synopsis, your written submission also is the same?
Same, my lords, on the same lines.
Why you have stated position of the governor under Article 163?
No, not this governor, generally governor.
No, it, point 3 at page 656.
It's,
56 of your written submission.
my lords, this is a
Nothing.
federal structure, well, not insofar as this impugned order I'm talking about.
In general.
In general, man. I'm not dealt with the impugned order in specific at all.
Constant Assembly debates. Article 143 there.
Please. In fact, my lord, the discussion, I've enclosed those copies all over discussion, my lord. Ultimately, my lord, as your lordship, the discussion is there to what extent, it all depends upon facts of each case, my lords, which your lordship will consider.
Yes, sir.
I'm
Anybody
grateful to my
else?
lords.
Anybody else? Immediately, yes.
I'll make my submissions after Dr. Singhvi.
Yes.
Dr. Singhvi is
Balance,
on.
I will
Initially
be
say-
doing it on 12th, Balance. I will do it on 12th,
12th, sir. Yes, we'll finish it on 12th.
unless my review
The
petition
complainants,
succeeds.
complainants have all completed?
Yes.
Yeah. They completed last.
You have submissions to make? No?
Reply to reply.
After the reply by Dr. Singhvi, sir. All right.
Balance, after my reply,
Again, if you
Balance,
go on then,
normally-
this
no,
rejoinder
after my reply,
adella.
I am a rejoinder, Balance. I will be doing a rejoinder. There can't be a
One minute,
reply
one minute.
after
Yes,
that.
sir.
Balance, after I reply, I had opened the matter, Balance. It has to be, if somebody argues after me, Balance, then I will need a reply to that also. No,
Then it will
except
go
my
on.
learned friend. No,
See,
except my learned friend on my
Whatever you
side.
want to reply, file by way of a reply, and you want to any clarifications later, you submit on that day because you have not submitted at all. And sir, also, if you want 5 minutes, that's all.
No,
Oh, sir.
no, ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Huh?
ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೆಸರ ಗ್ರಾಮನ. I have to show it to the court. It is not.
No, my learned friend can.
No, he's sailing with you, sir.
No, I thought it's somebody else, fellas. I thought I didn't see his face.
Dr.
He can
Singhvi,
argue after me.
No, I said I'll make my arguments after you complete your arguments.
No problem. He's on the same
Yes,
side.
yes, that is
I
what
thought
is.
it's somebody else arguing.
No,
Well,
no.
It is
I'm only going to supplement what you make, what
No,
you
that's not
submit.
right. I misheard.
Without repeating what
thought-
you said.
I thought it's somebody else. I'm sorry.
No,
So ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 464 ಇದೆ. ಅವೆಲ್ಲ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ತೋರಿಸ್ಬೇಕು.
ಇರೋದನ್ನ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನುಂಗಿಲ್ಲ. ಈಗ ಹೇಳಿದ್ರಲ್ಲ, ಗ್ರಾಮನೇ ಇಲ್ಲ, ಜಮೀನೇ ಇಲ್ಲ. I'll show. Where is the village? Where is the? I'll show.
All right.
Okay.
So this will go on and on. I am
No,
not.
no,
going
I'm
to-
only going to reply. No, sorry, I am going
Right,
to
1 minute,
reply.
sir. 1 minute, 1 minute. The right of reply is always there. You have submitted, right of rejoinder submissions is always there. If any clarification to that, yes. We'll, not, you can't go on and on like this and it's not it becomes a circle, sir.
Whole day it was argued saying that Kesara Grama is not there.
No,
I will
1 minute,
show
sir.
where is
What-
Kesara
1
Grama.
minute. For whatever you have submitted, they have a right to reply, they will reply. Then after that, it's not that you have a right to reply. It's not like sir rejoinder, filing sir rejoinder, sir submissions here.
Reply to reply is unknown, sir. Unknown.
But they will, sir, you, 1 minute.
I don't know why my
You
learned
have
friend
made
is-
some submissions. They have a right to rebut, 1 minute, rebut those submissions. If it is by way of new things, what can be done?
No, I don't
In
know why.
justification, they will say whatever is there. Allah, Atara, I can grant time, that's not a thing, but it will go on. How long do you argue the same thing?
So 12th, Malas, 12th.
New proposition, where are the new propositions, sir? You have submitted the whole day on 31st from 10:30 to 4:45. We'll see. You also want to clarify?
With respect to the chief minister's role that your lordship.
All right, let Dr. Singhvi sir finish it. We'll see, yes. 15 minutes. No. We'll see. First, let the respondents finish. Avatte ಮಾಡ್ತೀರಾ sir ನೀವು?
Petitioners, yeah. ಅಲ್ಲ,
Petitioners.
ಅವರು ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ ಮುಗಿಸಿದ
The moment
I don't
Dr.
want to
Singhvi
repeat.
completes, you have-
Yeah, I'll immediately start.
Malas, let me just make one thing clear. If anybody has any new point, they should give it to your lordships today or tomorrow. Because if when I'm rounding it
Today,
up,
no new points,
wait.
sir.
after my finishing, if somebody argues
No,
other than Mr.
just a
Ravi Kumar,
moment. Then you submit
let
whatever
this
you want to
one-
submit.
That's your lordship.
If you want to state about the role, please state. Then Dr. Singhvi sir will reply to that also.
That's all. Well,
I will hear you. How long will you take?
5 to 10.
That's all. Then you, if you're ready, you state. Yes.
Lordship,
Obliged.
Your lordship had put forth rules. What is the role of the chief minister ultimately in this entire matter?
Yes.
Key words are check period. Check period, your lordship. What happens is in all prevention of corruption matters, the date in which the position of power was held by the person, that is critical. Check period is what is taken into account for any irregular accounts that have entered into the person's account or the wife or any other family member. If the check period is gone into, then all of this falls in place. Your lordship, ultimately, we are only looking at when are the periods in which the petitioner held a certain post, and that is the time during which all of this took place. Your lordship, it is only between the year 1996 to 1999. 1996 to 1999,
Deputy Chief
he was the
Minister.
deputy CM. That period, your lordship, is the denotification period. I'm not going to expand further. The 1996 to 1999 is the entire denotification period which took place, and subsequently is the year 1999 to May 1994. That is the period when
2004.
2004, wherein the petitioner was not in power since he had lost his elections. Therefore, your lordship, that period is the lull period. Nothing takes place then. After that is during the period of 2004 to 2007. That denotification portion is over. So therefore, 2004 to 2007, the conversion phase starts. So from 2004 to 2007, documents are already there and they have gone into in length in that. So that is the conversion period. Subsequently, 2008 to 2013, your lordship, this is when this transfer takes place from A4 to A3 to then A2. That happens between up to 2010. Your Lordship, between the year 2013 to 18, when he is the chief minister, at that point of time, A2 takes over. The vice gives all the representation stating, give us compensatory land. So the phases of denotification, phases of conversion, and then phases of submissions of representation, and then seeking compensatory lands. Your Lordship, the key period that the petitioner seems to state is that all of this took place when they were not in power. Your Lordship, what happens is the year 2018 to 22 is critical. 2018 to 2022, the petitioner was very well an MLA. Now, it is not about which political party is in power. It's ultimately, did the individual hold a position of power or not? He held a position of power at that point of time. And at that point of time, what happens is that the 14 sites that are allotted are done at a government guest house, done specifically for that. Your Lordship, what happens is A2 doesn't go to the sub-registrar's office when MUDA gives this.
That's permissible in law.
That is permissible under the
For the
Registration
purpose of
Act.
registration of sale deed.
Registration of sale deed, that's permissible under the Act only for the person who's exempted from his presence there.
Disabled.
Disabled is one. There is also a list of people who need not be present at the sub-registrar's office. And that
So
is
you're attributing the connection to power.
absolutely every single act that has taken place has been done on behalf of the petitioner, and that has been established all through. And then subsequently, when actually the year of 2023, when all of this is unfolding, at that point of time, the petitioner says, all right, take my 14 sites, give me 60 crores. And so starting from the period on which we start with denotification, where A1 makes A4 to do all of this. That is, the petitioner asks A4 to do it. Up to the time they say, all right, give me back my money. From then onwards, the role is established. Your Lordship, we have only given a set of judgments which the others haven't, and only those we will mention, Your Lordship. These are only with respect to check period. Check period, Your Lordship.
In a Prevention of Corruption Act case.
In Prevention of Corruption Act cases, Your Lordship,
Yes.
I'll
from
very quickly-
Period A to period B.
period A to period B.
Date of joining service till the date of search.
Absolutely. And in most of the cases, Your Lordship, it is more of disproportionate income, and therefore they calculate the income during the time when he was in power and when he was not in power. In this, there is a
But
slight
how is the
shift.
concept of check period relevant to this, or you're trying to paraphrase that to this?
If we are drawing a parallel, in this, there is no money that you could attribute to have entered into at that point of time, but it is directly attributable to the acts that have taken place during that time. Your Lordship, and also with respect to what is the role of all of these judgments, Your Lordship, I will not take Your Lordship into detail, but all of these judgments only state that even if let us assume that the wife, that is A2, would be probably not working, or would have a source of income, maybe an agricultural source of income, and would file income tax returns. Nevertheless, the courts have held that if the person who's in position of power has purchased certain properties in the name of the wife or in the name of any other family member, it would still ultimately be attributable to them and their role in all of this. Directly, Your Lordship, all of these judgments, Your Lordship, I have,
Paragraphs, Hakidira?
Your Lordship,
You've
we've put
indicated
in.
the paragraphs of these judgments?
Paragraphs
Yes,
have
yes.
also been mentioned, Your
Yes,
Lordship.
yes.
In Ponuswami's case, Paramasivan's case, Balashankar Lingam's case, then
Yes.
Ponnumudi and Soundararasu, and also Wahidida Jayaraman, Your Lordship.
All right.
All of this directly on the point of when a particular person is in power. And that should probably connect the dots, Your Lordship. That's
So that's the link that you're trying to draw.
absolutely. And to say that I was not in power when all of these 14 sites was allotted, he was definitely in power.
No, not in power is not the submission, but not taken any decision directly or any recommendation made by him. That is the submission.
Your
He was
Lordship.
in power, that they accept, that's a matter of fact.
Please,
Yeah.
Your Lordship, anyway, the judgments are clear. We don't need a direct recommendation or any letter from them. If we are able to show the link at that point of time. For example, how I've been able to establish that the time when he was not elected, there's a lull period. But all the times that he's elected, activities have taken place. So that is sufficient. And the question always should be, what is the role of A2, A3, and A4, as opposed to asking what is the role of A1? Because A1 is established very clearly. A2 and A3 and A4 could be at best aiding or abetting. And that is something, it's just a matter of trial. But with respect to A1, it's very clear. That's about it.
All right, yes. Yes, now, Professor Sir, you have heard the council also. Elladakku seri reply on 12th. Singhvi Sir?
Yes,
On
Malas.
on 12th, sir.
Yes, 12th, Malas.
12th, we'll take it at 10:30 or at 2:30?
Well, it's not at 10:30, but maybe around 12 or 11:30 or
All
something.
right, we'll take it
I
at
will
12
come
ish.
to the court. Yes.
Yes, sir. 12 o'clock.
Yes, Malas. Obliged.
Heard the learned council Ellardu Hakpade and council Srimati Lakshmi Iyengar appear for which respondent, for the fourth respondent. The respondents have all completed their submissions. The learned advocate general has also completed his submissions for the reply submission of the senior counsel, Dr. Abhishek Singhvi, and the senior counsel, Professor Ravi Verma Kumar, list this matter on 12th. 12th, we should be concluding this, sir.
Yes, Malas. Yes. Obliged.
ಏನಾರು ಇದ್ರೆ 5 ನಿಮಿಷ ಅಲ್ಲೇ ನೋ ಡ್ರ್ಯಾಗಿಂಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್. ಅದೇನ್ 15 in the 10ಗೆ. Let them finish it first on that day. Huh? What do you want to say? The legal submission, sir. ಮತ್ತೆ ಅವತ್ ನೋಡ್ 12th. Yes, ma'am. List on 12th at 12 PM. 12.
The judgment supporting.
Let us hear. Yes.
No, I don't have anything more to say.
Yes, sir.
I have done whatever I had to.
Yes, sir. Yes.
The judgments which I have given along with the note, Malot, the full judgment copy has been enclosed, Malot.
ಅದಕ್ಕೆ ಇದೆಯಾ?
Allah, separate
Separate
compilation.
ಕೊಟ್ಟಿದ್ದೀರಿ.
Separate compilation has been,
There are about 12
Yeah.
compilations of judgments now.
we want
Bari 2,500 page judgments ಕೊಟ್ಟಿದ್ದೀರಾ.
for a 6-page prior approval.
Yes, sir. We'll see. Yes, madam. Yes.
Grateful.
Now ಅದೇ ಹೇಳೋದು for a 6-page prior approval ಇಷ್ಟಬೇಕಂತ.
Allah.
Now,
Mr.
we-
Raghavan has-
ಹೇಳಿದ್ದು.
Mr.
The-
Raghavan has come.
role is sort of explained by the senior counsel Lakshmi Iyengar. Now we will reply to that.
I'll do. I'll do. No, interim order needs to be.
That will be extended.
It took so long
For what?
to explain the role.
That is my investigation. That is my investigation.
Your Lordship, the League of Extraordinary Gentlemen went on a marathon. Ultimately, a lady had to take your Lordship through a 100-meter dash.
Let's see. Well, hear it on 12th. Yes. List the matter on 12th at 12 PM. We'll start at 12 sharp. Sir will be appearing physically or Singhvi sir?
No, Malas, I will be, I'm coming there physically, Malas. That's why. I'm very
yes,
grateful.
yes. That's fine. Yes.
Yes.
Barakadi. $30. Settlement. Then child is there, is it?
End of late settlement.
Take it. Give it. No problem. Give it. Where the child is there, please give it. Yes. Get that matter, madam.
First matter, there are 5 petitions, all of them are present.
498A. No, let the mother stay out with the child in this rush, not. Oh, fine, yes, fine. All right, yes. No, they are the accused,
498.
but where is the complainant is present?
Itself, I make a call to the complainant, she is not.
Not willing to settle.
Not,
Huh?
she is not well, Malas.
Not well.
Yes.
We can close it. Settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, but
When the time speak of, on 16, the order has been passed to the family.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? ಮತ್ತಿನ್ನೇನ್ ಕೊಡಿ. ಎಸ್. ಇಲ್ಲೂ ಏನು ಡಾಡ್ಜ್ ಮಾಡೋದು? ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆದ್ಮೇಲೆ ಕೊಡಿ.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಚೈಲ್ಡ್ ಪಾಸ್ಪೋರ್ಟ್ ಒಂದು ಕೊಡ್ಬೇಕು, ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
Child ದ
ಚೈಲ್ಡ್
ಕಂಡೀಷನ್ ಇದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ?
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Passport is expired. It was done when he was 6
So
months.
both of you cooperate and get get it extended, and visitation and holding of the child or the passport child is in whose custody? Child is in whose custody? Mother's custody. So you will apply for renewal or reissuance. Expire agiro passport or itkondren bitren. Yes. All right. Kodi. We'll close it. Don't ಎಲ್ಲ ಆದ್ಮೇಲೂ ಡಾಟ್ಸ್ ಮಾಡೋದು ಬೇಡ. ಎಸ್ ಪಿಟಿಷನ್ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಆಲ್ ರೈಟ್, ಯು ಟೇಕ್ ಇಟ್ ಎಸ್ ಸೆಟಲ್ಡ್. ಕಂಡೀಷನ್ಸ್ ನಿಮ್ಮ ಪೇಪರೇ ಕೊಡಿ, ಅದು ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೊಡಿ. ಗಿವ್ ದಟ್. ವಿಜಯ್, ಪಾರ್ಟೀಸ್ ವೆಲ್ ಬಿಫೋರ್ ದಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆಸ್ ವೆಲ್. ಇಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ, ಅದರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ. One of the condition is closure of the proceeding. Point number 11, ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ ಅದು. The learned counsel appearing for the complainant would submit that the settlement is indeed arrived at, but has some grievance about the passport of the child being held with the husband. The learned counsel representing the husband would submit that the passport has expired 3 years ago. The child is now 8 and the passport had expired when the child was 5. Therefore, the respondent mother in whose custody the child is always, it is always open to her to apply for reissuance of a passport in accordance with law. Adon last al hakbittu it's closed. Ashte tane nim expire agiro passport mele so undertakes both the matters. Yes. Next, 230 mood matter thodi. Panindra sir. ನೀವು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು ಅಂತ ಗೊತ್ತು, ಅದಕ್ಕೆ ಕೇಳಕ್ಕಾರ್ತೀನಿ.
Girl and boy knew each other in college.
Girl and boy knew each other.
But this is the wife's complaint. After marriage, after I filed a divorce petition, first time she files one complaint, Millards, alleging
Pokso.
Foxco on the wife.
Post.
not-
Sir, Pokso.
Not on the wife, not on the child. After the divorce petition.
No, 1 minute. What was the age when both of you knew each other?
But she says in 2019-20, we came to know each other.
Uh,
Now
What
we
was
are
the age, her age then?
17 years and 8 months.
All right. After that you get married when?
That's on 2021.
No, but what was the age of, what was her age when she got married?
She was born in 21 years.
No, the girl was above 18. Yes, all right.
Fact, on 25/10/2021, I had given a complaint saying she's coming. My father had given, that's the second accused.
Second.
Father, she has involved father, mother, aunt, everyone in Foxco 498A SC.
Pokso.
Fox. Now, my lords, 21, I give a complaint. She gives an undertaking, she's not trouble. Then, my lords, the boy and girl elope and get married in Hassan, registered marriage. She admits marriage. Then, my lords, there is trouble between us. Then she gives one complaint to the police saying that he is troubling me, counsel. We go undergo counseling, it fades. Then, my lord, 498A, she lost this. By that time, I had filed a divorce petition. This honorable court grants anticipatory bail on 27/5/2024 on 498A. 6/6/2024, she files a complaint saying I had, my lords, raped her in 2000. That is invoked. 498A first complaint, there is nothing.
And Jagdish sir.
Yes.
25 days ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ. ರೆಕಾರ್ಡ್
ಈಗ ನೋಡ್ತಾ ಇದ್ದೆ.
ನಾನು ಈಗ ನೋಡ್ತಾ ಇದ್ದೆ. Date 26/6/24 crime, 24/7/24 charge sheet.
Yes.
Very fast, sir.
And in all her records, father's name is shown as Rajappa.
Who is that?
How she says, my father is Nayak, to claim my lord's SC/ST, she says, her school records, everything shows Rajappa. She says, Rajappa. and
Who is
the other-
Rajappa?
She says, I am the adopted daughter of Rajappa. My father is Nayak. Please see her school records.
See State Atrocity Act 6. Charge sheet has to be filed within 60 days. It has to be filed
ಇದು
within-
3-1 R&S ಬೇರೆ ಇದೆಯಾ ಅದಕ್ಕೆ?
What?
Any offense left?
R&S.
Nothing more. I don't know. Manoj, everything.
Hmm.
The boy had to spend 1 month in custody, though he had anticipated. Parents spent about 15-20 days in custody.
Object achieved. Yes. The learned senior counsel, K.N. Panindra, appearing for the petitioner. The petitioners, petitioners accused 1, 2, 4 are knocking at the doors of this court, calling in question filing registration of special CC 1493 of 2024. The facts would read as follows. It transpires that the first petitioner and the second respondent complainant knew each other while pursuing their engineering. They fall in love, get married on 23/10/2021. You have a child also? 13/1?
13th of January 2023, the marriage.
On 13 January 2023. Soon thereafter, it transpires that the relationship between the first petitioner and the second respondent complainant flounders. And on the floundering of relationship, certain proceedings are instituted. The husband institutes proceedings seeking annulment of marriage before the family court. Thereafter, the wife registers a complaint. For what offenses is surprising to notice. The wife registers a crime for 498A. There should be no problem with that. The wife further registers proceedings for offense punishable under section, further registers complaint for offense punishable under section 376, 354C, 506 and 34 of the IPs. Charge sheet is filed by the police invoking POCSO. The reason for invoking the provisions of POCSO is before marriage, the relationship, the petitioner is alleged to have had physical relationship with the complainant, at which point in time she was less than 18 years. The marriage having taken place later and the floundering of the relationship between the two cannot give rise to an offense under POCSO which had taken place earlier, albeit prima facie. All the other offenses would touch upon the disputes between the two and the crime being registered as a counterblast. This is again a view that is prima facie. Therefore, till the appearance of the second respondent complainant, there shall be an interim order of stay of further proceedings in special CC 1493 of 2024. 1 additional SPP, 2 emergent notice returnable by 26th September.
Number 2, Shamki Reddy.
Settlement. An offense? Offense.
506. Plus it's between a husband and wife. The complaint is the husband as against the wife.
Extorting money.
Extorting money is what they claim. However, the matter is settled with the party.
Who is the complainant? Why, if the wife asks you money, it is extortion, is it?
No, my lord.
ಆಯ್ತು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಬಿಡಿ ನಮ್ಗೆ ಯಾಕೆ ಕೊಡಿ. Yes.
The respondent number 2 is appear via VC.
Huh?
Respondent number 2.
All right, yes, give it. Settlement close ಮಾಡಿ ಅನ್ವಿಜ್.
Application under 359 sub.
So and so, totally. Application is filed on 359 BNSS, not 320. So and so. Settled. Copy ಅವ್ರಿಗೂ ಕೊಡಿ. 363 ಅಲ್ಲ.
Copy ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಕಾಪಿ ಕೊಡಿ. ಗವರ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? Not this, sir, your settlement copy, sir. Give it.
Petition copy.
Petition copy no ilva?
230 mood matter ಮೇಲೆ copy sir not.
Other, yes. Forgery, sir. 465,
A
420.
connected 498A case was settled before the court on number 22, my lord, today itself.
Today?
Yeah, criminal petition.
Oh, all right, sir.
That is
Yes.
2019, my lord.
No problem. Close it, yes. I would.
Order sheet signatures.
The respondent number 2 appear is.
Thank you, my lord.
Yes, thank you. Yes. Hello, pages karbiಡಿ.
Three, page 6, seal number 36.
NDPS.
NDPS.
ಹಾ ಗೊತ್ತು.
It was for dictation on fifth,
Today not possible.
please,
18th.
18th.
Yes.
Obliged.
List on 18th. Next.
Page 7, 37 to 41.
Wherever entry order is there, they'll continue. Will they rather 18th?
40 minutes.
Where there is no entry order, they'll come on 18th.
40 minutes, last 2 dates it is.
Huh?
40, serial number 40.
ಹಾ ಏನಾಗಿದೆ ಸರ್?
Date also it is urgent. Last date also it is urgent, my lord.
Last date?
Also it is urgent for today.
This date also it is adjourned. Can't help.
Right.
List on 18th.
List number 1 is arrested.
All matters where interim orders are not there, they'll come on 18th.
My lord, my submission, material number 42.
Wherever interim orders are there, they'll get continued
My lord,
for period for 2 weeks.
My-
Next date of hearing.
my submission, my lord, petition number 1 is subsequently arrested, my lord, and
Subsequently arrested, why?
after filing of this petition.
Why?
For offenses under 376, my lord.
376.
376.
Parallel.
Now the parents who are in Chhattisgarh, my lord.
Huh?
Now the parents who are in Chhattisgarh,
ಅದು ಯಾವ್ದು ಮುರಳಿ ನೀವೇನಾ?
please.
Interim order ಇಲ್ಲ ಅಲ್ವಾ?
Still has entry matter. Last date also it is.
ಅದು ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಎಂಡ್ ಡೇಟ್ ಮೇಡಮ್ 16, 17 ಅದ್ರ ಬದಲು 18th ಬರುತ್ತೆ. 17th in the fresh matters list. All right. Serial number 40 ಮಾತ್ರ. Because he is arrested, yes.
Please.
Entry order ಇದೆಯಾ? $55. Tomorrow ಆಗಲ್ಲ madam. Tomorrow not possible. Wherever interim order is there, they'll continue for 2
Number
weeks.
52, my lord.
ಅದೊಂದು ಮಾತ್ರ day after tomorrow ಹಾಕಿ.
52, my lords, it's concerning default bail.
52, my lord, summoning of.
52, my lords, it's concerning default bail, my lords.
Default bail ಯಾವ್ದು?
52.
52.
Please, my lords.
52 also list day after tomorrow in the fresh matters.
Summoning of the.
ನಿಮ್ದು default bail ಆ? Where is it? Pokso na? Pokso is 20th. ಯಾವತ್ತು?
Serial number 62, my lord.
Huh?
Serial number 1 was arrested subsequent to filing the petition.
ಜಗದೀಶ್ ಏನ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ಇದೆಯಾ?
Serial number 12.
That day after tomorrow ಹಾಕಿ ಮೇಡಮ್. ಅರೆಸ್ಟ್ ಆಗಿರೋದು day after tomorrow ಹಾಕಿ.
Serial number 40.
Supposed to be listed fresh matters, my lord. Serial number 50, my lord, the matter was listed before you last.
ಸರ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ
Fresh list ಆಗ್ಬೇಕಾಯ್ತು, fresh.
ಆಗುತ್ತೆ. ಇವತ್ ನಾಳೆ ಅಲ್ಲ. 17ಕ್ಕೆ ಆಗುತ್ತೆ ಸರ್.
Serial number 39.
Serial number 12 for settlement.
ನಾನೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಹಾಕಲ್ಲ.
Subjection over.
ನೋ ಅದು ಬರೀ ಆತರ ಇದ್ರೆ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ರೂಲ್ ಅಲ್ದೇನೆ. 1 minute sir. Don't argue with the court officer. Now,
Madam,
no. If I have issued notice without granting an interim order, it will come only in admission after the appearance.
My lord, serial number-
Yes, sir.
serial number 39. my lord. ಅದ್ ಬರ್ಕೊಂಡಿದೀನಿ ಬಿಡಿ.
actually second list ಅಲ್ಲಿ ಇತ್ತು madam ಅದು.
ಬರ್ಕೊಂಡಿದೀನಿ.
Madam, charge ಇದೆ madam.
Madam, serial number 12 ಯಾವಾಗ